Okay, good afternoon, everyone. I think there's no way but to start now. Okay, so welcome. Uh, let's start the ball rolling amidst all the tech glitch. Okay, formally, good afternoon again, everyone, and good morning from India. Before I continue with my introduction, I'd like to uh, inform everyone. Please let me know using our chat room if there are problems with the audio. So for everyone, especially our esteemed speakers and resource persons this afternoon, welcome to Copy Talk, a webinar on copyright for academics. As I've mentioned, I'm Ray Valenzuela from Central Philippine University. In this webinar, a panel of experts in intellectual property and copyright are here with us virtually to discuss a very important issue for academics. This webinar is a collaborative effort between Central Philippine University, Henry Luce III Library, and San Sebastian College, Manila Graduate School of Law. So as we know, a pursuit of learning amidst global pandemic means embracing the digital resources as an essential part of digital teaching. And as I mentioned, we have gathered a pool of experts. So let me just quickly introduce them this afternoon. Right now, we have our two guest speakers here, resource persons here, and some will be coming later. So first, we have Dr. Shri Ram, the Deputy Librarian at the PAR Institute of Engineering and Technology. May I have a word from Dr.
Yeah,
Shri?
good afternoon, everyone, and good morning from India. Thank you. Thank you. It's a pleasure to be here.
Thank you, Dr. Shri. It's really an honor. Um, and also, we have the Dean of the Graduate School of Law of San Sebastian College, Recoletos, Manila. We have no other than Dean Rodel Taton.
Hello, everyone. I'm Dino Deltaton, and I would like to say good afternoon here in Manila, and we're very sorry for the connection problems that we cannot connect in Facebook Live right now because there are so many participants, really. Thank you, Dr. Reza, and thank you, Dr. Sri, and all the rest of the participants.
Thank you, Dean. So thank you very much. I believe we have more than 1,300 participants, and this made a bit of glitch in our system. But we promise you, we're going to record this event this afternoon, and we're trying to work out other platforms. Every now and then, I'll be updating you if we can get through our FB Live using San Sebastian Recoletos College. Graduate School of Law FB page if it works. But well, anyway, no matter what, this show must go on. So let's start it. Without further ado, let me introduce our first speaker. Okay, but by the way, there's a bit of changes in our sequence. We will have something specific about the library first, and then we will proceed to the Philippine legal setting, and lastly, zero in on intellectual property in terms of scholarly work. So for our first speaker, who will discuss about copyright in the classroom teaching, the library perspectives, we have a respectable scholar, an international author, and also a nodal officer of intellectual property rights cell of TIET since 2018. He has initiated many activities to promote IP or intellectual property related activities at the Institute, involved with IPR policy, patent searching, filing, and providing resources related to intellectual property rights. As I mentioned earlier, he is a deputy librarian at the PAR Institute of Engineering and Technology in Patiala since 2015. Before joining TIET, he was working at JP University of Information Technology, Ceylon since 2002. He's a PhD in LIS from Osmania University, Hyderabad. He has been a Commonwealth Professional Fellow at University of East London, UK in 2013, and ICSSR NRCT Fellow at Thammasat University, Bangkok, Thailand. He has published more than 50 papers, wow, in different peer-reviewed international and national journals and conferences, and edited 4 books. I think it's increasing in the making. My dear participants, it is my honor to have this afternoon Dr. Shriram. Dr. Shriram, I give you the floor.
Yeah, thank you, Dr. Raza, for such a nice introduction and giving me the platform for this is very important topic on today's pandemic scenario, where most of the teaching and learning activities on halt. So I would like to thank the director Kuyo and the dean Rodel Rotten for giving me such a wonderful platform, virtual platform to interact with the people from Philippines and other part of the country and other part of the world as well to hear a very important aspect in current pandemic scenario. So, as administrator, as a teacher, or students, everyone is in uh, uh, at the crossroad where it is very difficult to decide what is the future of education is going to be. So, in India, there is a huge transformation is taking place where most of the teaching and learning activity is going to be online, and there is a tectonic shift in the education sector where we are moving very fast from face-to-face teaching to online learning activity. In the meantime, the teachers are also at a crossroad where they are finding some kind of difficulty in understanding how they are going to prepare their contents which are free from copyright obligations, or they should not indulge in any kind of content which is going to hamper the learning activity of the student in future. As a librarian, I often come across so many questions related to the copyright, how the teachers are going to use the digital resources or digital materials available in the form of through different publishers, or how if they want to circulate some kind of materials either by scanning or copying, whether it is fair to use those things or not. Sometimes I come across with the questions whether I wanted to use some images, especially the circuit diagrams or any kind of small audio clips or video clips. So how these things can be handled during the online teaching system. So this is very pertinent talk initiated by Philippines, and also to make people understand that where the library can be very proactive in providing such kind of information to the teachers, to the students, so that they can deliver their content in a most comprehensive way, and they should not be trapped in a scenario where some kind of copyright violations or copyright infringement should be avoided. So, keeping in that point in my mind, I'm going to cover just brief about the coverage of the copyright, because one of the speaker is going to have more details on this topic. I'm also going to cover what kind of key aspect of the copyright laws, especially the Indian copyright or US copyright. Then the fair use and fair deal policies provided into different copyright laws, and what are the exceptions available which can be beneficial to use the copyright material or any other material which is useful in the in the classroom teaching. And then how the library can provide some of the key resources available in different platform so that it can help the teaching and learning. So keeping these aspects in my mind, I'm just covering a brief what is the covered into the copyright. The copyright basically is the legal term used to describe the rights that a creator have over their literary and artistic work. So this is basically a law which gives autonomy to the creators and authors of material, where their interest is protected through different. These materials are which the copyright covers the range of materials like literary works in the form of books, articles, journals, publications, chapters, all these things. If a creator is related to a musical work like sound recording, songs, any other accompanying material with the musical words, the dramatic works, including the accompanying material with the music, pictorial, graphic, sculpture works, motion pictures, sound recording, architecture plans, drawing. All these are the provisions which are available to each and every creator or authors. As is all this have been defined by different law and has been given by the WIPO, which describe the coverage of the copyright material. The holders hold some kind of exclusive rights which make him to reproduce the content, to redistribute it, derive from the work, display into the public, or perform in front of the public. All these are the bundle of right which has been given exclusive right to the authors in terms of the reproduction, distribution, derivative, display, or perform in a community and communicate to the people while working in different kind of under scenarios. So Indian copyright is a very comprehensive copyright laws which gives different kind of rules, regulation, legacy, and other aspects which comprehend a lot of information related to the copyright in India. So we are governed by the Copyright Act 1957, and there are a lot of amendments coming at different point of time. And the most comprehensive copyright law amendment was 2012, where we have included a lot of information related to the digital content because of the proliferation of this internet technology, and a lot of amendments and important items included in 2012 amendment. So the big question is how to use these materials in the classroom teaching. So there are a lot of options available. As a librarian, we should educate our teachers or educate our students how they can use these materials into the classroom teaching. So one of the most common options available to us is the public domain materials, which are free from the copyright laws. Then application of CC licenses, how they can attribute the different licenses available in Creative Commons, and they can prepare their contents using those licenses and distribute reassemble those contents and distribute among the students while the content. Then some of the rights available through exceptions, how the copyright exceptions can be used for the purpose of learning and teaching. Then fair use, this is very important aspect. It is given in every copyright laws. These exceptions are basically related to how much amount, how tactfully they can be used for the purpose of learning and teaching. Then if not anything available, then there are a lot of permissions facility provided by the content creator or publishers. Using those permissions, the copyright materials can be used for the classroom teaching. So I take one by one, and before any faculty use any kind of copyright material, they must go or must assess the three-step test. So the first step is certain special cases. We have to understand that what is the case is. The case might be the classroom teaching. Then the step two is do not conflict with the normal exploitation of the work. We have to understand that anything available in a tangible mode is containing some kind of copyright aspect related to the material. So we have to understood that our teacher has to understood that we should not conflict with the abnormal things, or we should not do any abnormal activity which gives a problem to the author or as well as the user of the material. Then step third, do not unreasonably prejudice the legitimate interest of the author. So meaning by this is we should not indulge in unethical activities which is the against the law related to the copyright. So understanding about three-step process is very essential to deal with the copyright material. And before using it, you should make an assessment ourselves how we are going to use those materials for classroom teaching. So there are a lot of stuffs available there where we can use those materials for the copyright activity. So one of the is the public domain material. So those material which are available in which copyright period is expired, or the material which is available from government sector, or material which is released by the copyright holder into the public, and the copyright owner directly dedicate works to the public domain. So we have to, as a librarian, we have to understood these concept and try to find out the related resources or public material, the public domain material which are pertinent to our curriculum or pertinent to our academic activities. Try to map those materials into the course curriculum and educate our users how they can use these public materials for the purpose of learning and teaching. Then there are time period available, because most of the copyright laws provide how we can use those materials if they have completed their copyright period. So for Indian copyright, it is saying that any author who has completed any author who has completed its life plus 60 years from the day he passes away, so those materials become copyright free. US copyright gives 70 plus years, or any materials published before 1923 can be used in copyright free mode. Similarly, Australian copyright acts provide 17 years after the life of the author. So these we have to understand that if any material published in a year, so after calculating these periods, we can decide whether the material is copyright free, or that can be used for the purpose of learning and teaching. So there are a lot of resources available. One of the famous resources is public domain review. It provides huge amount of materials that can be explored for the purpose of copyright, for the purpose of teaching and learning. It gives a lot of historical and other materials which are related to the history, culture, and any other domain can be found from this here. So, 19 founded in 2011, there are a lot of information, and it compiles the material which are out of copyright and try to compile the comprehensive catalog of the books, and anyone can enjoy the free access and share the material without any restrictions. In India, we have Avilek Patel. This is another very famous copyright-free materials from all the Indian history, freedom fighting, and whole range of materials are available for the purpose of uh, 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 academic activity. There is very nice work by Project Gutenberg, which gives you a lot of information related to every subject area, where 60,000 more free ebooks are available, which can be used by the academic fraternity for their classroom teaching and other activities. The plus one is Public Library of Science is one of the most classic example where all the materials are available in as a free, and the people can enjoy the most useful materials in research oriented materials free of cost without paying any charge. And we have to understand that how these materials are related to our curriculum activity, and these can be used for the purpose of academic and research activity. There are a lot of people using for their presentation use clip arts or images. So there are public domain clip arts are available, which can be used for the purpose of there are public domain pictures available, which can be used for the purpose of their animation, for the purpose of putting graphics into the their presentation, or creating videos. All these materials can be used freely without any problem. And only thing is we have to provide a lot of attribution to the creators, or to the reservoirs where from where we are taking these pictures. A lot of questions we came across how to use the images. So the images which are available on internet, so we have to uh, make our users understand that how these images can be used for the purpose of different activity. So using Google advanced image search facility gives beautiful examples. We have to understand that how these option can be used for the purpose of so you understanding about usage right, and understanding about how these images can be used, and what kind of creative common licenses or what kind of license associated with the image that can be used for the purpose of uh, uh, using the interpretation. So free to like usage right, giving free to use, share or modify, and even commercially such kind of options are available. For example, let us choose this famous monument of Taj Mahal, where many people use to represent historical activity. So searching by image, then understanding about the license associated with that image is going to help you to understand that this image is free from copyright and we can use it, and the uh, photographer may provide the options that he is giving this license under creative common attribution share alike, to share it, remix, attribute, and share alike options, so that it is become free from any copyright obligations. So understanding, making them understand how to search the Google and how to attribute whether these images are under copyright, that can be a very very important aspect by the librarian point of view. There are a lot of statistics so how these there is a violation of copyright on related to images. So USA most infringement cases as per the copytrack.com give a lot of information how these images are being infringed in case of using in different activities. So I must show that you must be recognizing this uh, picture is our the legendary Amitabh Bachchan. So I taken this one from one of the TV shows, the Comedy Nights. So you see that audio in this section has been muted to avoid copyright infringement. So very often we come across how this why because the song which he is singing is picturized on him only, even though there is a copyright instruction related to the related to the songs played on the screen. So library has to understood that if any material acquired from in the form of video, audio, we must understand that we must satisfy the copyright exceptions, or we must understood that if we are distributing, it should be for a period or for a small section. So many copyright acts shows that if you want to use any image or any visual, any video or any music, that should be 3 minutes or less pertaining, and that also related to most pertinent part of the section related to the course. It's not like that you are playing whole range of music in front of students, or you are uploading the whole range of whole music video or music or any audio having a full length of the section. But we have to understand that which part of the section is most important to the course content, and those part only can be put into the lecture or in the classroom teaching, especially the online version. So there are a lot of infringement across the globe where the youngsters ranging from 16 to 24 years old are infringing the copyright violations, and 38% of those things are through copyright infringement, and about 34% are by stripping, stream ripping. All these activities are taking place in case of musing. So it is creating huge loss to both the creator as well as the copyright holder about this activity. So Digital Millennium Copyright Act is one of the most pertinent, which allow us to use the material in the most protected way, initiated by the WIPO treaty. So it gives a lot of criminal procedures which protect the rights of the creator, and also provide the digital rights management activity, which gives a fair use policy of digital content. Then another most important aspect is the Creative Commons licenses. Understanding about the license, different licenses by creative available through Creative Commons is very good, going to help you, the teachers or students, to use the materials in a most favorable ways. And they have to understand that these common Creative Commons licenses provide you liberty to use in a copyright, not copyright free mode, but in a most protective way, which allow you to modify, share, and even you can have the financial obligations, financial benefits from those using those copyright materials using CC licenses. So there are several licenses available. So those licenses can be used for free distribution of any other work which is on under copyrighted materials. So understanding about the public domain, CC by SA, CC by ND, CC by NC, and CC by NCSA. All these are understanding about how these materials are associated. What are the licenses associated with those learning materials, which can be used in a most productive way. So the green part of the traffic light gives you the most secured way of using the copyrighted material for teaching and learning, and maybe they be free or maybe reverse common Creative Commons licenses. So traffic lights I'll just skip because maybe other part of the understanding, and summarize this whole CC licenses in this table, where the public domains are attribution required, then you can remix it and commercially use, and free access to cultural work, and even you can provide into the open definition. So all the green part of the table gives you the liberty where you can use the materials in a most free manner, and the red part is going to give you the options where you have to be careful about the sharing the materials over the internet and using it for any kind of other activities. Then it is just skipping the different, so you can visit Creative Common traffic lights. It is very illustrative explanations given for each of those materials on Creative Common website, and it's very easy to understand that what kind of licenses associated with the Creative Commons and how these can be used even for the economic purpose using these licenses. Then copyright exceptions. So every laws of the copyright, even WIPO or US or maybe Philippines also, they have given some kind of exceptions where we can use those materials into the classroom teaching using after following those exceptions for the purpose of classroom teaching, or for the purpose of creating online content or developing a course module for the students, even especially in case of distance learning. So all these rules must be adhered to and are well understood by the teachers, so that they can use the materials in a most freedom way, so that they should not violate any kind of violations related to the copyright. So understanding about the exceptions, as a librarian, we should first we should understand, and then we should teach our faculty or students how these exceptions can be applied into the classrooms. So there are many exceptions available where copyright laws have been part of the major intellectual property right since 1986, starting from Berne Convention. Then World Intellectual Property Organization has given the protection of revising the laws and providing the another law which is related to World Intellectual Property Organization Copyright Treaty in 1996. Then another related to the performance of the dramatic and other activities related to WIPO PPT. Then TRIPS agreement related to the trade, and now the Indian government had banned the use of different mobile apps originating from the from the Chinese region. So this is also the people, the country is uh, uh, China's people are they are arguing that this is a uh, TRIPS violation of TRIPS agreement. But looking at the security, looking at the privacy, so every countries have their own policies and procedure to use any materials or any activities. So keeping in view of the users' right. Then Beijing Treaty is on the performance of audiovisual performance. So understanding about all these treaties and laws help our teachers to make more comfortable how they can use the materials related covered under these treaty and share those materials for the classroom teaching. So Indian Copyright Acts under Section 52, we have a lot of provisions where we can use the reproduction of any material or a teacher or students for the course of instructions, or if you want to put these materials in a questions or answering those questions or research or private study for the performance, all these are gives the exceptions right for the students or teachers to use those materials. Similarly, US copyright section 110(1) gives the performance by or display of copy of a work, a legal copy by the instructor or pupil of the course, face-to-face teaching activities of the non-profit profit educational institution in a classroom. So all these are similar instructions available in US copyright as well. And again, the Australian copyright very clearly indicate that any book, any material, if you have a 10 or more pages, the 10% of the number of pages or a chapter, which if it is not more than 10% of the pages can be used in a classroom teaching. Similarly, if a digital content, then 10% of the words of a chapter, if it is not less, of not more than 10%, or 10% of the musical word. So likewise, every copyright provisions provide some kind of exceptions which can be helpful in classroom teaching. Then another option is strengthening the open educational resources. So this now popularity of OER is becoming more and more useful. So wherever possible, we have to understand that we should, as a librarian, we should evaluate the importance of those materials. We should map whether the open educational resources are covering the curriculum requirement, and then understanding how beautifully these materials can be used, views with the permission, engage in 5R activities. These 5R activities are retaining, reuse, revise, remix, and redistribute, so that we are not violating the copyright laws. So how these are going to fit into the Creative Commons licenses? So going from CC by NCSA till public domain materials, all are coverage under open educational, all are considered as open educational resources, while CC by ND and CC by NC are not OER. So understanding about these terminologies of licensing of Creative Commons is going to help to assess the open educational resources for the purpose of teaching and learning. So copyright is not an enemy, but it is the fair use is your friend. So we have to understand that if any material is copyrighted, it doesn't mean you are not going to use that. So there are fair use policies are there in every copyright laws. In India, the fair use and fair deal policy is there. Similarly, in US copyright laws, fair use doctrine is there. So understanding about the fair use is very, very important, and we as a librarian we should promote this such kind of information to the faculty members, where we can use these materials for the purpose of creating content or sharing the for the fair use. The pain rule applies. So pain rules is saying by saying is the purpose and character of the use. So if any material we are going to use, we have to understand that for what purpose you, then amount, how much amount we are using, then nature work, what kind of work is there which we are going to use, And then what is the potential market value or economic impact if we are going to use any material under fair use policies. So commercial purpose, if you are if you are able to define that whatever copyright material, if a library subscribe, it must, because we are paying huge amount of money for the subscription of e-books, e-journals, or purchasing the copy, and we should have a policy, we should have an option so that we can share the material to the people we are not in the campus because of this pandemic situation. So providing the material through remote access is going to solve the problem. And understanding that because we have to help our student under educational activity, so purpose is education and the technology is remote access, that is considered to be a fair use of copyrighted material. Then amount taken, so every copyright material is, so we cannot share all the materials or all the book, entire books or entire article of a volume of a journal. So but there is a, provision where we can use a single article from issue, or 10% of one chapter, 10% of material or one chapter, whichever is lesser is the amount considered to be as a fair use in case of if you want to share in a face-to-face teaching, or in case of online teaching material, teaching learning. Then nature of underlying work, so any highly creative material we cannot share into the classroom teaching, while any factual or historical activity can be easily shared to the students. So that examines how we have to examine that how creative is the work, or whether it is going to hamper the creativity of the material. So understanding about the uh, uh, creativity of the material, or understanding about the factual or historical value of the materials, this can be easily shared to the students in classroom teaching. Then impact of sharing on the probable market value. So there are many cases where it hampers the market value or economic impact of the creative, especially in case of movies. So in suppose if you have shared any kind of cinema or any movies recently released, that is actually going to hamper the potential market value of the director or actor or any other person associated with those activities. So we have to see that if a pertinent part or significant part of the matter is not going to hamper the value of the content, and it is going to be used in a fair way. Then understanding about various concept of the copyright terminologies or copyright this. So in making our users understanding about whether they are infringing the copyright, or using about the course pack. So such kind of questions very often I came across, that what is the copyright infringement. So the infringement is if you are using any materials which is protected by law, or violating the law which is not permissible to use by the law. So infringement covers many things, which is the privacy. If we are violating the laws, which is unauthorized copying, distributing, and selling of especially the movies, song, and all these things. Then theft of the material which is claimed by other person, and saying that it is your own, some kind of activity must be understood by the and their repercussion of these materials on their future career. Then freebooting in terms of an unauthorized copying of the online media, especially videos onto the website. So many songs, many other materials which are copied from one place and put into the YouTube channels or any other website, saying that they have the creator of these materials. So all this concept must be clearly understood by the teachers or by the students, so that they should not be indulged in any kind of infringement. So why these things are happening? Because of the price is so high, maybe not available freely, or for the purpose of testing and evaluation. Maybe they found it is useful, or they find that it is anonymous. I cannot, I can claim that it is their own, or freedom of information. All these things are responsible for the infringement. So many a time we came across that, can I use a legal material for the course pack? So course pack compilations, maybe chapters or any other textual materials. So under no circumstances such kind of things can be done by any authors. So there was a famous, very you can say judgment from Delhi High Court for the purpose of where the photocopier vendor has made a bundle of different chapters from different publishers and make a pack of the course material. So even the High Court has given a judgment that photocopy isn't a copyright violation, using the fair use policy, that it is being used for the purpose of education only. So it is not associated with any other kind of activity. So this was very we have to very careful that how much amount we are using and how we are using to help our student in case of if you are compiling any course pack for the classroom teaching. Then use of legally material for the sharing on e-learning platforms. So we have to understood that whatever materials we have legally acquired or purpose, that can be used in a most secured manner. Then restrictions of platform for access from outside. Only we have to ensure that these materials are available through registered user only. Access blockage once the class is over, or wherever possible, it is preferred to share the link rather than putting whole material into the e-learning platform. So all these things are, we have to understand that and make educate our users that how what are the subscribed content available in the library that can be properly shared and to the e-learning platform and can be used for the purpose of academic activities only. So maybe some kind of maybe you also come across where the linking of web pages, these questions are related to the copyright violations or not. So it is not actually copyright infringement, but we have to understand that it should not be deep linking. So wherever we are linking such kind of material, it should be very clearly and prudent to the link on top of the site or home page rather than going into deep into the site if it is not available for the public access. Then sharing articles through email to the students is also not a good idea. We have to understand that rather than sharing email, the whole article through email, it is advisable to share the link to the users so that it is also help students to reach the particular platform and explore more and more articles of the subscribed resources. So if you teacher shares one article to 100 students, so 100 student might not visit to the site and our usage going to hamper. So it is better idea to navigate to direct users to reach to the platform from where the article is available, so that they can explore related more articles related to the course content. Putting the materials into course reserves also, this is another options where library can help to provide legally acquired materials and restrict through technological measures such as remote access or password login system, so that only a genuine user can access those materials. Then another options is when if anything is not available under fair use, so it is there any options which can library can help to use the materials. Then where option is permission to use the materials uh, for the purpose of classroom teaching. So teachers are advised to contact the librarians. So librarian may help them to go through these 5-step procedure to check whether these materials can be acquired or permission can be obtained for the purpose of course reading. So determining if permission is required, identifying who is the owner, then identifying whether any rights are required to access those materials, contact the owners and negotiate if payment is required, and get the permission and with the writing that we are going to use this material for the classroom teaching. So there are copyright clearance center is there. So every publisher who, if you want to use any material, the copyright clearance center might be going to help you in accessing the materials. Also providing very clear guidelines on the library portal through IPR cell. So we have our IPR cell website, and we are providing a very clear guidelines to our users how these materials can be used in the copyright free, helping if any user having some kind of copyright workflow. So if they want to protect their ideas, or if they want to protect their materials under copyright, so helping them to understand the workflow, how they can be protect their materials for the and they can protect their contents through copyright rules that library can help them. So information about various national and international IPR policies, another aspect where library is going to play a major role for educating our users for this. So we compile a lot of information from different agencies and make available to our faculty members understanding about IPR. And we have also our IPR cell as well, IPR policy as well, where we have included a lot of materials related to how they can write thesis, how they can use the materials, what kind of citations they have to provide, and what kind of references. We conduct a lot of workshops and seminars to teach our students and about how to write theses, how to write articles, how to get citations, how to write sites using different kind of bibliography management software like Mendeley, Zotero, EndNote. Likewise, we educate them to about these kind of techniques available for fair use and copyright obligations. Then in nutshell, I can say that if any students or any teacher want to use some kind of copyright material, they have to understand that how much quantity they want to use from a book or article or chapter, then how they can use those materials in terms of those four cases in amount, then using the pen rule, and then how can they share if a single copy of the material is available for the face-to-face teaching or in case of online teaching. So the face-to-face teaching maybe the material may not have. Online teaching may not have the same kind of facility as well as per the face-to-face teaching. So we have to understand that whatever materials that can be used in a face-to-face teaching is not actually applied for online teaching. So understanding about those rules, those activities for using the copyright materials of related to the text or graph or diagram or cartoon or picture or movies, we have must educate our users so that they should not trap into any kind of copyright infringement, or whenever they use they must provide a proper citation to the materials in case of uh, PPTs, or they should also provide the attribution under the different CC licenses. So this is what I wanted to cover the library aspect, where we can help our users to in classroom teaching in case of yeah, they are going for online and offline teaching. So over to Dr. Raish. So I'm sure that I have covered to within time.
Thank you so much, Dr. Shri. That's a very comprehensive and enlightening lecture. I know we really need that to at this point in time, and we have a lot of issues in copyright in the online platform. It's really good that you mentioned about the rules, the steps, and how to determine the licensing or the copyright of a particular material, and all those um, Creative Commons licensing, it's public domains, and all the tools. It's really very important. So probably for those who have questions, I know this is not just useful for librarians, but also for academics. Um, teachers and faculty or professors for that matter. But well, anyway, we still have more. Please save your questions or put it in our chat box here at the Zoom in our Zoom webinar, or maybe although right now I think we're luckily on FB Live. So I think you can use Henry Luce the Third Library FB Live. If there are problems with the audio, don't worry, because we're working it out with SSCR, and we have recorded all this. Let me proceed to our next speaker. Okay, so our second speaker, attorney. He has more than 20 years of professional experience in both the government and the private sector, serving in various capacities ranging from technical, supervisory, and part of the top management. He is also an educator, having taken up teaching at a local university in the Philippines, where he handles courses in law, business, management, and research. Currently, he is the director of the Bureau of Copyright and Other Related Rights of the Intellectual Property Office of the Philippines. His office handles policy issues on copyright and related accreditation of collective management organizations and adjudication of cases on copyright, among others. Previous to this, he was employed as Chief Risk Officer of a government financial institution where he was connected with for 15 years. He was also previously connected with the umbrella organization of Philippine exporters working in the area of policy, advocacy, and business development. So, friends, participants, I would like to introduce to you Attorney Cuyo, the Director of Intellectual Property Rights of the Philippines. Sir, I'm giving the floor to you. Thank you. Dr. Cuyo, I think we need to turn on okay, I think we're good.
Okay. Am I coming in clear?
Loud and clear. Thank you so much, sir. Okay.
Very much. Thank you, Dr. Shri. That was a very comprehensive presentation. I think the only missing now is to be able to contextualize what was presented by Dr. Shri within the Philippine context. So I'll run through portions of this presentation which are almost similar to the presentation presented by Dr. Shri. Thank you. So I was tasked to talk about intellectual property and scholarly works. However, I must already warn you that since the bureau I am in charge of is copyright and related rights, most of the discussion will also focus on copyright as a specific intellectual property and in relation to scholarly works. So let me briefly introduce our office. We are the Intellectual Property Office of the Philippines. We are the lead agency of the government, Philippine government, mandated to implement state policies on intellectual property. We are created by virtue of a law, that's Republic Act 8293, otherwise known as the Intellectual Property Code of the Philippines. Our office, as you see in this building, we are located right across the most photographed mall in the Philippines. We are right across Venice Mall. So if you would like to visit us in the office after the lockdown, then feel free to visit us at the office. So as the Intellectual Property Office, we are in charge of most intellectual property, the registration thereof. So For purposes of our audience, we cover the following, and uh, I am giving certain words just to recall for better recall of the audience. So we handle registration or application for patent protection. So when we talk of patents, we are talking about inventions. We also handle utility model registrations. So when we talk of utility models, we are talking about innovation and industrial designs, as well as trademark. This includes your logos or any visible mark which would identify the source of a product or a service. And lastly, the bureau I am in charge of is the Copyright Bureau, uh, where the main item for registration are literary and artistic works. So just to be clear, what are scholarly works? I will be using the term scholarly works not in the strict sense, but in the sense that uh, of any material or document that are produced, especially in schools and universities. So when we talk of scholarly works, we have thesis, dissertations, any research output, scholarly articles, especially those appearing in journals. Then we have books or even the letters or communications shared within various departments of the school. It may not come it may not be very obvious, but there are also certain works that may be included in thesis or dissertations, as well as research outputs that are considered as part and parcel of literary or artistic works, such as photographs, musical compositions, as well as charts and diagrams. So all of these are examples of scholarly works. So the question is, are scholarly works protected by copyright? The answer to that question would be yes, because under the Intellectual Property Code, as I mentioned earlier, it protects copyright, protects both original works of literary and artistic creations, as well as derivative works. So the thesis dissertations that I mentioned would normally fall under literary and artistic works. However, dito, when you register with either the National Library or the Intellectual Property Office of the Philippines, we classify theses and dissertations under the catch-all provision of the law, which is other literary, scholarly, and artistic works. So as I mentioned, the law protects grants copyright protection over original literary and artistic works. So I just summarize the main categories the various enumeration under the law. So we have literary works, dyan po pumapasok yung books, pamphlets, other writings, articles, those are all considered literary works. So even your thesis and dissertations are literary works. Then you have works of the performing arts. This would usually be your dramatic or dramatical musical compositions, as well as choreographic compositions. And then you have your works of the visual and applied arts. This would refer, for example, to drawings, illustrations, sculpture, architecture work, etc. And then we have audiovisual works, or what you may know as films. Films and audiovisual works are also protected as original literary and artistic creations. Then you have computer programs. There's another category which you call advertisements, pictorial illustrations, and advertisements, but in truth, they would fall under any of the previous categories, either as work of visual and applied arts or as an audiovisual work, if it's if it's a series of moving images. Then the law also protects derivative works, which includes dramatizations, translations, adaptations, abridgments, arrangements, and other alterations of literary or artistic works. And then you have collection of literary, scholarly, or artistic works. So compilations or collections are protected as derivative works. Anong ibig pong sabihin nito? When we talk of derivative works, these works, the collection themselves, are protected separate and distinct from each of the original works that are part of the collection. So may copyright protection yung original literary work or scholarly work, which is part of a collection, but the collection itself will have a separate copyright protection if indeed the manner or arrangement is imbued with some sort of originality, because that's the requirement under our law. Originality is the requirement for copyright protection to vest in your work. So when does copyright vest? Works are protected by the sole fact of creation, irrespective of the mode or form of expression, as well as their content, quality, and purpose. In other words, the moment that you finish or transformed or expressed in a material form your work, then there is already copyright protection. So copyright protection vests from the moment of creation. Now, the question that you may ask is, what rights do I have as the author of or creator of scholarly works? We have to remember that in your work with a university or school, either as a student or part of the faculty, you can either be one of two things, either as an author or creator of scholarly works, or as mentioned and as adequately explained by Dr. Shri, you can be the user of scholarly works. So you are granted economic rights, such as the right of reproduction. These are 7 exclusive rights, which we call them exclusive because only the author or creator is authorized to exercise any of these 7 rights. From the right of reproduction, the right of adaptation, the right of first public distribution, the right of rental, the right of public display, public performance rights, and communication and making available rights. So we have 7 economic rights. As I said, they are called economic rights because these rights, the exercise of these rights, allows the author or creator to make money and to earn from his literary or artistic work. Then we have moral rights granted to the author or creator. This is basically separated into 2 major categories. The first and the last bullet would be what you call as the right of attribution or / false attribution. The first bullet would be the right of attribution, meaning that you have the right to require the authorship of a work to be attributed to you. And the last bullet would be the right of against false attribution, which is the right to restrain the use of your name with respect to any work of which you are not the author. Then you have the right of integrity, which is second, the right and to object to any distortion, mutilation, or other modification or other derogatory action in relating to your work, especially if they would be prejudicial to your honor and reputation. The next thing that is asked, even in an academic setting, is who owns the copyright to these works? So the general rule, the author or the creator, whoever made the work, is the copyright owner, the first owner of the copyright. And the author is defined under the law as the natural person who created the work. Take note of the word natural person. These are just to distinguish it from a juridical person. So under our law, only a natural person can be the first owner of the copyright because only a natural person can be an author. Then you have the other rules on copyright ownership. Joint ownership, governed by co-ownership. If you are an employee of an educational institution or a university and the work that you did was part of the regularly assigned duties, then the copyright ownership shall belong to the employer. There's an exception to this when there is an agreement to the contrary. When it's not part of your regular duties, even when you use company time and resources, then the ownership of the copyright in the work belongs to the creator or the author. There is no exception to this, so there can only be a transfer of the copyright that is made, which is not part of the regular works of an employee, through assignment or transfer of the copyright. Then you have commissioned works. The rule here is that when it is a commissioned work, to the commissioner belongs the work and to the creator belongs the copyright. Here we are introduced into the concept of the uh, dichotomy between material object and copyright. Magkaiba po yung copyright at yung mismong object. Just to give you a concrete example, a book produced is the physical object or the material object. So if you commission the writing of a book, then the book belongs to you. However, the copyright, which is an intangible intellectual property, would belong to the creator or the author. Exception, when there is a written stipulation to the contrary, such as when the creator or the commissioned person agrees that everything belongs to the commissioner of the work. Then what we call as collective work. This is a work that is created by two or more natural persons at the instance and under the direction of another, with the understanding that it will be disclosed by the latter under his own name, meaning the other person under whose direction a work is made will be the one who will be named as the author of the work, and the contributing natural persons will not be identified. For purposes of this presentation, I would like to call your attention to a little known provision of the law, Section 230 of the Intellectual Property Code of the Philippines, because a lot of the questions that arise out concerning ownership, who owns what, the copyright to a work, can be answered with the adoption of an intellectual property policy. This particular section was introduced into the copyright law in 2014 through Republic Act 10372. It says that schools and universities shall adopt intellectual property policies that would govern the use, the creation of intellectual property with the purpose of safeguarding intellectual property creations of the learning institution, meaning the school, as well as its employees, and adopting locally established industry practice fair use guidelines. This will also be the basis. We are actually organizing now a public consultation, not public, but a consultation with the Association of Librarians next week, with the hope that we can come up with a mutually agreed guideline, especially as within the context of the post-COVID environment. You know, everything is now online. Even the sharing of materials and references will be done online. And there are library institutions that would like to offer new services for their students online also. So we will enter into a dialogue using as as legal basis, Section 230 of the Intellectual Property Code. And also, in relation to scholarly works, because this is also a frequently asked question, I draw your attention again to a little known provision also in the copyright law of the Philippines, pertaining what if you earlier submitted a literary, photographic, or artistic work to a newspaper, magazine, or periodical. Can you now use the same literary, photographic, or artistic work for the dissertation or thesis or research output that you would like to produce in the school or the university? And we are guided by this section, which says that whenever you submit a literary, photographic, or artistic work to a newspaper or a journal, uh, for publication, it shall constitute only a license to make a single publication unless a greater right is expressly granted. Therefore, the license stops at the moment that the uh, article or the literary work appeared in the first or single publication of the said newspaper, journal, or magazine. Therefore, it reverts back to you. In fact, under a license, hindi naman po natatransfer ang copyright. Copyright remains with the owner of the work or the author of the work. Only the use of the work is authorized under the terms of a license. How long does protection last? You were introduced to the Indian law where the protection is 70 years. Here in the Philippines, we still use the minimum protection period provided under the Berne Convention. So the magic word here is 50 years. In India, we learned earlier that it's now at 70 years. In fact, there are other jurisdictions also, other countries where the term of protection is 100 years. But the more usual term of protection would be either 50 years or 70 years. Only exception here for works of applied art where the protection is 25 years from date of making. So what are the things I need to be conscious of? This time, we will be talking about what should you be aware of or should you be conscious of whenever you try to incorporate or to integrate the work of another into your scholarly work. So I think this is similar to the process that Dr. Sri ran you through. You do I did this from a reading of the law. I think the first questions that you need to ask is the work that you want to incorporate considered a work of the government? Why is this important? Because under the copyright law of the Philippines, a work of the government does not enjoy copyright protection. So I said here that if your answer to this question is yes, then generally there is no need to ask for permission for its use. I said generally also because there's an exception when you want to make or to use a work of the government for commercial purposes, then there is a need to ask permission from the agency who made the work. If it's not a work of the government, then it means it must be a private work, and therefore you proceed to the next question. What is the next question? The next question to ask is whether there is a copyright that subsists in the work. Is it part of public domain as mentioned earlier, or is there a subsisting copyright in the work? If the answer to this question is yes, you proceed to the next question, which I will discuss later. And if no, generally okay to use except for the right of attribution. Why generally okay to use? Because again, you also have to contend with plagiarism rules. Third, would the use fall under any of the statutory fair uses? You were introduced earlier by Dr. Shri to the concept of fair use. Here, we'd like to distinguish and qualify between statutory fair uses and general fair use. Sa batas po kasi natin, under Philippine law, there is a portion that's 184.1 from letter A to L, okay, where there are specific situations mentioned in the law that would qualify as fair use. So for easier recall, we call these instances as statutory fair uses. If the answer to this question is yes, then it is okay to use because the law says under section 184, it says that any of these instances, for as long as you meet the requirements, would not constitute copyright infringement. If the answer to this question is no, then you proceed to the next question. What is the next question? The next question is, would this use qualify as general fair use? If yes, then it's okay to use. If no, then you proceed to the next point. So what is the next point? The next point is that if you come to this point, following the questions I mentioned earlier, and you arrive at question number 5, there is no other way for you but to get permission from the copyright holder. Well, how do you do that? You can either contact the copyright holder individually, meaning you determine who is the copyright owner in a work, and you contact him directly and ask permission for its use. Or, and this is the more practical way of doing this, is by contacting an existing and accredited collective management organization. In the area of text and publishing, mga textbooks, mga reference materials, there is an accredited collective management organization in the Philippines. It's called the Filipinas Licensing Society, or PhilCols. So instead of having to contact the copyright holder directly, you may want to go through the existing collective management organization in the Philippines. Why do I say accredited? Accredited because under section 183 of the law, of the copyright law in the Philippines, dapat daw yung mga nagla-license or nagma-manage collectively ng copyright ng iba't ibang creators or authors must seek accreditation from the Intellectual Property Office of the Philippines, in particular with the Bureau of Copyright and Related Rights. So without this, without the accreditation, anybody, any organization that seeks to license and collect collectively would be running afoul of the law, meaning would be violating the provision of the law that they must be accredited with the Intellectual Property Office of the Philippines. So let me just go through this because this has been exhaustively mentioned already by Dr. Shri. So I would like to quickly go through them. Statutory fair use, you'll notice that I started with B because, as I said, it's from A to L in the law. So I just use the particular portions which are applicable to an educational environment. So when you want to make quotations, that's fair use. However, the quotation should be only to such extent justified for the purpose. If you want to make reproductions and communication to the public of any work, then it is fair use if it forms part of a report of current events. While this may not be applicable to the making of a learning material or to a scholarly work, this might be applicable in some instances to school activities. Then you have the inclusion of a work when it is only for illustration for teaching purposes. So that's statutory fair use. However, take note, medyo tricky itong letter E because there is the mention of the word for as long as it is compatible with fair use. So that will be covered in the next slides. The recording made schools is or educational institutions is also a statutory, is considered as a statutory fair use. The use by or under the direction or control of the government when it is in the public interest and is compatible with fair use is also fair use, statutory fair use. This may not be applicable to most schools that are privately run because here we're talking about it being part of the government for it to qualify for this particular statutory fair use. And again, letter I just put this because it may be applicable to an educational setting. The public performance or the communication to the public of a work in a place where no admission is charged, and if for purposes of charitable or educational purposes, whose aim is not profit making. Then lastly, we have letter L of the statute section 184.1, which is the reproduction or distribution of published articles or materials in a specialized format exclusively for the use of the blind, visually and reading impaired persons. Ito pong provision ng law, this particular provision of the law was a result of our of an international treaty called the Marrakesh Treaty. So an authorized entity can an entity such as a school can actually transform or convert a published article or material into an accessible format copy. Ano ba yung mga accessible format copies? This would include converting it into a braille or some other form which now facilitates the use of these materials by the blind, visually, and reading impaired persons. The Intellectual Property Office of the Philippines actually has released already the guidelines for the implementation in the Philippines of the Marrakesh Treaty. I invite you to go to our website to look for the memorandum circular issued by IPOPHIL on the Marrakesh Treaty. May conditions po yan. You need to seek recognition if you're a public institution or accreditation, some sort of an accreditation or authorization if you are a private institution. Then we come to the general fair use principle, 185.1, when it's for criticism, comments, news reporting, teaching. I don't know if you noticed in comparison to the Indian law, the Indian law actually uses the word for this, for a similar provision, uses the word multiple copies for classroom use. In the Philippines, we amended this in 2014 also. So it now reads, teaching including limited number of copies for classroom use. What is limited number? That's not provided in the law, but I think that should be provided for by an implementing rules and regulation. We are coming up also with an implementing rules and regulations for section 184 and 185 of the law on fair use and statutory fair use. So we invite all interested parties, including maybe some of you in the audience here, to comment on the implementing rules and regulations once we are ready for the public consultation. This is also mentioned already, the pain, the purpose and character of the use. What does this mean? All these four factors will be considered by judge of the court whenever he decides on whether a particular use without the permission of the copyright holder is considered as fair use. So he takes into consideration all of these factors. I say all of these factors because you cannot rely only on a single factor. It has to be all four factors in its totality. So the judge or the court takes a look at the purpose and character of the use, the nature of the copyrighted work, the amount and substantiality of the portion used, and the effect of the use upon the potential market for or value of the copyrighted work. I also included here already Section 187 because you may be asked also about private copying or reproduction. The law is actually a bit problematic in the sense that in the first paragraph of Section 187, it provides a single copy made by a natural person exclusively for the purpose of research and private study is considered a private copying. Okay lang daw yon. It's okay to do this. However, it says in the last clause of the first paragraph, subject to the limitations under Section 187.2. What are these limitations? You cannot copy an entire book or a substantial part thereof or of a musical work. So if you photocopied an entire book that is for research or private study, then it's still under the law considered as it stands now, is still considered as infringement. Yeah. I don't know if I should touch this, but to go quickly, infringement versus plagiarism, you have here a Venn diagram that illustrates that these are two these are two separate concepts, copyright infringement and plagiarism, but there is some sort of an overlap between the two, such that not all copyright infringement is plagiarism and not all plagiarism is copyright infringement. Plagiarism, you are very familiar with this. It's the deliberate and knowing presentation of another person's ideas as one's own. Just to distinguish between the two, one is a legal consideration, the other is ethical. You need copyright to subsist for you to commit copyright infringement. Here in plagiarism, even if no copyright subsists, you can be accused of plagiarism. Copyright holder is the offended, generally the offended party in a copyright infringement case. Plagiarism, the community at large is offended because you represented your work as that of, as yours, even if it's the work of another. So I guess that's my end of my presentation. Thank you very much for listening.
Thank you very much, Director Kuyo. That was really a comprehensive and in-depth discussion. May I request to, I could move on with the sharing. Okay, so just a minute. I think this entire presentation is really very useful for all of us. So, just a minute, I can't get into my video. Stop. Okay. Okay. Okay, just a minute. My video doesn't work. Anyway, it's just my video. So thank you so much. It's really a very helpful discussion on the topic. But I think the last one is also as equally interesting. So without much further ado, I'll proceed first to our last speaker this afternoon for his topic. Okay, let me introduce him. Okay, he graduated in Doctor of Civil Law at the University of Santo Tomas, magna cum laude. He also finished in Master of Laws in the same university. He took his Bachelor of Laws at the University of San Agustin and AB Political Science from the University of the Philippines in the Visayas. He is currently the Dean of the Graduate School of Law at San Sebastian College, Recoletos, Manila, and Graduate School of Law and a founder of Taton Law and Notarial Office, also a professor of law at the University of Santo Tomas, Faculty of Civil Law, an advocate in consumer rights. You see him as one of the hosts of Consumers Desk IBC 13. He is a CCP consultant in copyright and was former consultant of Food and Agriculture Organization of the United Nations to discuss about intellectual piracy and copyright in the academe, issues and jurisprudence. May I give the floor to Dean Rodel Taton.
Hello, everyone. Good afternoon.
Good afternoon, Dean. Really clear.
Yes, I think the two guests, our two speakers here, have exhaustively discussed the topic on copyright, and of course, we have a background from India, and also based in our experience here in the Philippines. So, what else should I discuss? Director Cuyo has exhaustively explained the law and even the experiences and the cases. So we'll just try to discuss the other issues, and we'll try as much as possible to discuss also the relevant jurisprudence as related also to the discussion of Director Cuyo. And again, my apologies also for the late broadcast of our present of our program here this afternoon, of our webinar, because of certain technical issues. There. So my topic is in the copyright in the Philippine Academe, some issues and jurisprudence. The outline of my discussion would be, sorry. The outline of my discussion would basically be the following: the demands of the new normal. We'll try to discuss or maybe just a rundown of the scope of the copyright law of the Philippines, which was really discussed by Director Cuyo earlier. Some issues and jurisprudence. Some questions like on the clash of rights and interests here, production versus reproduction issues, the fair use, and whether or not education is an exception to copyright infringement, or is it? Some remedies and penalties that we will be discussing as well if we have enough time. There. So the demands of the new normal would bring us to the creative side of the professors and of course the universities also. So we are caught to be creative, innovative for the lessons particularly. Earlier we have took note of the scope of copyright, especially for the universities and colleges, and we also noticed and reminded by Director Cuyo about Section 230 about the duty of the university and colleges on the aspect of intellectual property. I have been involved in the university also, and also here with the thesis and dissertations of students in the Master of Laws and Doctor of Laws, and even in the College of Law, right now with the JD program in PUP and other universities like San Sebastian College, Recoletos, Manila. So, and also for professors that we are dealing with on our syllabus, learning modules, the lessons that we are preparing, sometimes we are not so aware that there are certain rules in copying, for instance, some visual aids or even audio or video materials that we will be including in our presentations or in the materials. And online, there are a lot of materials also that we will be using or that we can use. But the question is this: will we not be committing copyright infringement? Will we not be committing intellectual piracy in the course of preparing our course outlines, our course syllabus? And as we deal with the students, we have to teach the students to respect, of course, copyright and the property of the intellectual property of every person. So a lesson for professors, sometimes there is the concept of writing, copying, and even performing in the universities or colleges. So I took note of the question earlier about the in the Q&A while waiting for the turn for my turn, and I saw a question there about the syllabus being prepared by the professors. And that is very relevant question and an issue that we will try to resolve, taking into consideration the law that is applicable. And we know that in all these demands of the new normal for professors, universities, and colleges, there is always this copyright issue that remains. And thank you, Director Cuyo, for the reminder about the rule or section 230 for the duties of the universities and colleges as to the intellectual property rights policy. Because for the few schools that I have been involved with, there are variations in certain policies. Sometimes the teachers are caught having been in this gray areas or questions that they will be trying to resolve. Sorry. There's a problem with my sharing of my slides. Oh, there. So last time we have took note also of in social media, we have noticed a publication by a group of teachers who are concerned also for the authors of children's books, for instance, and even publishers. I've read a Facebook post about publishers who are reminding about the copyright and the respect for the copyright and intellectual property of authors of books and materials. So for the academic community, this should be a reminder for all of us as we prepare in this new normal and in this online learning that we are having right now, or for this semester particularly. So there are several realities in the academe, and some of these are presented in the slides. For the libraries, for instance, the acquisition of books. Earlier, there is a note that the libraries' acquisition of certain books are limited also. Right now that our classes are becoming online, the students may not go physically in the schools. So will the universities or colleges add to their book acquisitions, or will they allow for the copying of books, which earlier there was also a notation that photocopying of books may have questions on copyright, and until or up to what number can the libraries or the colleges or universities photocopy books for purposes of their students. And the students right now are in their houses. So that is a reality in the academe that should be actually resolved. And the library materials, there are certain materials that can only be found in the library, not even online. So, but I note also the digitization efforts of the universities and the colleges, or the libraries particularly, that they're trying to do and incorporate in their policies the questions on the use of materials and in their libraries. So I hope you have updated your policies on this also. Theses and dissertations. One of the first things that Director Cuyo earlier mentioned was about theses and dissertations and their reproduction. I remember when I was doing my master's thesis in UST, I am not allowed to photocopy more than, I think, a number like 15 pages. But there are others, or it may be calling for intellectual honesty as well. But I mean, this policy of a university is a very strong guideline that they can set for the students, especially in the thesis and dissertations which are not published, but these are protected by copyright, as we mentioned, and the universities and colleges have the duty also to protect this. And our copyright laws is giving a protection in this particular scholarly works and their reproduction. And that is a reality that students cannot photocopy or even borrow theses and dissertations overnight. So will this policy be changing in the course of the new normal in the universities or colleges? So can the sharing of the entire thesis and dissertation be allowed? That is a reality that the academy is facing. Photocopying and selling books or copying of books in the photocopy shops. This is common in law, Director Cuyo, for law students. And there are actions coming from the Intellectual Property Office and even in the NBI and the police. There are cases in the university area, the university belt, whose activities, or there are persons whose activities are photocopying books or making book alikes and selling this to the students, and some students also would be buying this book alikes. These are questions that are involving copyright, and it is a copyright infringement or a violation of a law. The electronic sources and the prevalence of piracy. Last time, I was also with Director Cuyo in the CCP in our webinar regarding piracy, digital piracy and online piracy for derivative works and works in relation to art. But this time in the academe, since libraries also opened their electronic sources and digitized, and in fact during the lockdown we were able to look into the collection of journals, which before we can only access them with the paid accounts or through the university accounts. But again, using these electronic sources and pirating them and using this in the universities and colleges and for the professors, that will be posing a question on intellectual piracy and copyright infringement. The authenticity or originality of online materials also. We may have able to get an online material, but is the material authentic or original? Or if we are preparing this for our students, will this not pose also a question of infringement and piracy in certain aspects? So for the university and the academe, that is a relevant question. Copying of films, visual aids, digital works, or using illegally sourced work, or even syllabus, the syllabus that we are preparing. So again, here we are presented with so much available online materials that if we will use may have a question on copyright infringement. And again, digitization of materials like book chapters, journals, etc. for the libraries. This is another example of looking into your policies. And I am not sure if the community of librarians or the association of librarians and universities were able to come up with a new norm for the new normal. And again, other materials are available online. So there are file downloads and sharing networks, which would also be utilized by individuals taking advantage of the copyright of authors and creators of work, and they share this, and this is obviously a violation of the law. These are just few realities in the academe that we are faced, and if we are not to be reminded about the copyright issues and realities, then maybe we should start digging into our policies and implement new policies and platforms to protect the creators, authors of of certain materials for the ACA team. As earlier mentioned, works are protected by the sole fact of their creation, irrespective of their mode or form of expression, as well as of their content, quality, and purpose. This was discussed earlier by Director Cuyo. There are laws, as earlier mentioned. So we have the Intellectual Property Code. We also have the Electronic Commerce Act. The relevancy of the Cybercrime Prevention Act 2012 may also be emphasized here because of the use of computer and online sources. Even the anti-camcording law may be relevant also for our discussion and for purposes of copyright and piracy, intellectual piracy at that. The international conventions, so we have the Berne Convention, we have the TRIPS Agreement. Earlier we have mentioned about the Marrakesh Treaty, which is a relevant international convention. And we take note that in the Philippines, we adhere to the international law as part of the law of the land. And of course, we have the case law or the jurisprudence. In our discussion in a bit, we'll try to discuss, if we have time, some of the cases, or at least the relevant cases. I think I will not be discussing what are those protected by copyright, and this were discussed exhaustively by Director Cuyo. So there are so many items there. Sorry. So the books, pamphlets, sermons, even theses, the dramatizations, the collections, all of these were properly discussed already. And this concept of intellectual piracy, I'm trying to look into a particular definition of intellectual piracy, but there was a definition of piracy, a separate definition of piracy earlier mentioned, even the Black's Law Dictionary. The intellectual piracy, for purposes of our discussion here, I use an operational discussion, including the discussion of the cases, so we can probably define intellectual piracy as an unauthorized act of duplicating, copying, or sharing a scholarly or creative work or digital work that may come with a whole spectrum of visual and effects in video or audio without the permission of the copyright holder, or does not fall in the exceptions provided for under the law. It constitutes a violation of copyright laws, of course. In the E-Commerce Act, piracy is the unauthorized copying, reproduction, dissemination, distribution, importation, use, removal, alteration, substitution, modification, storage, uploading, downloading, communicating, and making them available to the public. And if this is the work of another person, we are committing an intellectual piracy. And of course, piracy is a copyright infringement. And under the jurisprudence, infringement of copyright is a trespass on a private domain owned and occupied by the copyright owner. It consists in the doing by any person without the consent of the copyright owner of any of his exclusive rights provided for by law. That is discussed in the case of NBI Microsoft Corporation versus Judy Wang, GR number 147043. And I think this also is a portion which was earlier discussed also by Director Cuyo. So who owns the copyright? So the copyright is the owner of a copyright is the author or the creator, except for if it's an employee work, in which case the owner of the copyright is the employer when it falls with the exceptions, it would be the employees. For commissioned photos, engravings, drawings, paintings, and other works, the one commissioned the work shall own the work, but the copyright shall remain with the author or creator unless there is a written agreement to the contrary. For joint authorships, the co-authors shall be co-owners unless the work consists of parts and the authors of each part can be identified. For audiovisual work, so the producer, the author of the scenario, the film director, the author of the work so adopted, unless there is an agreement among the creators to the contrary. So in the case of letters, the writers own copyright to this letter. For anonymous or pseudonymous works, the publishers of these works shall own the copyright as they represent these authors, unless the contrary appears or unless the author's identity is well known or the author discloses his identity. So a quick review of copyright. This was earlier discussed also, economic right and moral right. So we are reminded about the reproduction of the work or substantial portion thereof as an economic right. This reproduction of the work is one question that is so relevant for the academe and the libraries also, and the universities and colleges, of course. Derivative rights or right to transformation of the works, the right to first distribution, the rental rights, the right of public display, the right of public performance, the right of communication to the public. Moral rights, the right of attribution of authorship, the right to make any alteration of his work prior to or to withhold it from publication, the right of integrity, to object to any distortion, mutilation, or other modification or derogatory action, the right against false attribution. So there are 3-step tests in copyright. The limitation of reproduction is provided for by legislation, as earlier mentioned also. Reproduction should not be in conflict with the normal exploitation of the work, and reproduction does not unreasonably prejudice the right of the copyright owner. And since there are questions on the right to reproduce, the prerequisites to continue enjoying exemptions of the law. First, the purpose of reproduction is strictly for research or study. Second, should not produce copies for direct or indirect commercial advantage, provided it is not for an entire book or a substantial of it. And in general, for any work where reproduction would unreasonably conflict with the normal exploitation of the work or would be prejudicial to the interests of the author. Earlier mentioned by Director Cuyot, only one copy, and it's only for personal use. For the copyright issues on the following, for instance, on the recitation or performance of a work after it has been accessible to the public, provided it is done privately and free of charge, or if made strictly for a charitable religious institution or society, work must be used privately and free of charge. The purpose is for charitable or religious institution or society. Making of quotations from a published work or newspaper articles and periodicals in accordance with fair use. It must be compatible with fair use. Extent of use is justifiable for the purpose extended or intended. For proper attribution, the source and the author must be mentioned. So this has been discussed also, fair use. So we have to consider fair use all the time. The purpose and the character of the use, including whether such use is of commercial nature or is for nonprofit educational purposes. The nature of the copyrighted work, the amount and substantiality of the portion used in relation to the copyrighted work as a whole, and the effect of the use upon the potential market for or value of the copyrighted work. In this particular case of Habana versus, in this particular case, a July 19, 2019 case. And this involved college English for today. I think many of you are aware of this already. And one of the questions there is whether there was infringement on the production of DEP. And here, as I mentioned, college English for today was involved, and this was allegedly copied. So whether Robles committed infringement in the production of DEP. A perusal of the records according to the court yields several pages of the book DEP that are similar, if not identical, with the text of college English for today. The court finds that the respondent Robles' act of lifting from the book of petitioners substantial portions of discussions and examples, and her failure to acknowledge the same in her book is an infringement of petitioners' copyright. According to this particular case, in determining the question of infringement, the amount of matter copied from the copyrighted work is an important consideration. To constitute infringement, it is not necessary that the whole or even a large portion of the work shall have been copied. If so much is taken that the value of the original is sensibly diminished, take note that the value of the original is sensibly diminished, or the labors of the original author are substantially and to an injurious extent appropriated by another, that is sufficient in point of law to constitute piracy. So the essence of intellectual piracy should be essayed in conceptual terms in order to underscore its gravity by an appropriate understanding thereof, said the Supreme Court. And this particular case repeated what we have mentioned earlier, that the infringement of a copyright is a trespass on a private domain owned and occupied by the owner of the copyright and therefore protected by law. And infringement of copyright or piracy, which is a synonymous term in this connection, consists in the doing by any person without the consent of the owner of the copyright of anything, the sole right to do which is conferred by statute on the owner of the copyright. As to the communication to the public by mass media for the information of the public and has not been reserved, reproduction or communication to the public by mass media for the information of the public and has not been reserved, the necessary attribution of the source must be indicated, and there is no reservation as to reproduction. I was just reminded about this particular aspect because when we were having our consumers desk last time, when we posted the same in Facebook, there was a question in Facebook on the copyright issue, and we were able to also explain our side as to fair use, and it was explained and it was allowed by Facebook community guidelines. I think this was also this portion was also discussed by Director Cuyo, which would cover illustrations for teaching purposes. Attribution is necessary both as to the source and the name of the author. And the recording made in educational institutions, the purpose is for educational purposes. So the recording must be erased in a reasonable time from broadcast. There are questions on this particular aspect, like our experience in the CCP and other jurisdictions. That is why it's always good to have a clear licensing agreement or agreement between the copyright author and a copyright owner and your institution if you will be using some works of another person or entity. So as to the work of government, I'll be discussing this case of this also in relation to the fair use and earlier in relation to the news that can be copied. Okay, this particular case of ABS-CBN versus Felipe Guzon and others. So this is basically a case involving the ABS-CBN live audio video coverage and broadcast of the arrival of a person from abroad, and the same was allowed. ABS-CBN allowed Reuters, and under the special embargo agreement, Reuters was allowed by ABS-CBN. And GMA subscribes to the Reuters and CNN. So it received a live video feed of the coverage of the arrival from Reuters. And GMA carried the news feed in its program, Flash Report. And so now there is a question that arrived in the court. So whether the news footage is copyrightable under the law. Under the Intellectual Property Code, it says yes. It is clear about the rights accorded to authors of various kinds of work. Sorry. Under the code, works are protected by the sole fact of their creation, irrespective of their mode or form of expression, as well as their content, quality, and purpose. Okay. News or the event itself is not copyrightable. However, an event can be captured and presented in a specific medium, as recognized by this court in Joaquin. Television involves a whole spectrum of visuals and effects, video and audio. So news coverage in television involves framing shots using images, graphics, and sound effects. So it involves creative process and originality. So television news footage is an expression of the news. So in this case, respondents admitted the material under review, which is the subject of the controversy, is an exact copy of the original. So respondents did not subject ABS-CBN's footage to any editing of their own. So the news footage did not undergo any transformation where there is a need to track elements of the original. So there was an infringement. Public performance or communication to the public of a work in a place where no admission fee is charged. The economic rights of public performance and communication to the public is involved here. So the purpose must be charitable or educational. So no fees must be charged by the one exercising the said acts. So like music in the school program that is allowed, but music in a restaurant may be subject to licensing and the economic rights of the copyright owner. Um, any use of the work for the purpose of judicial proceedings or for professional legal advice. So earlier also you were reminded about plagiarism and the difference between plagiarism and copyright infringement. And Director Cuyo presented a very graphic presentation of the difference. But there are also still questions about this in the academe particularly. So this case of uh, Justice Mariano del Castillo regarding plagiarism. The Supreme Court has the instance to say about this. According to this case, there was no plagiarism, that Justice del Castillo did not commit plagiarism. And at its most basic, plagiarism means theft of another person's language, thoughts, or ideas. To plagiarize, as it is commonly understood, according to Webster, is to take ideas, writings, etc., from another and pass them off as one's own. The passing off of the work of another as one's own is thus an indispensable element of plagiarism. And it also followed the definition earlier read by Director Cuyo on plagiarism as the deliberate and knowing presentation of another person's original ideas or creative expressions as one's own. According to the Supreme Court, the passages were merely used as background facts in establishing the state on international law at various stages of its development. So the Supreme Court went on to state that foreign authors' works can support conflicting theories. The Supreme Court stated that since the attributions to said authors were accidentally deleted, it is possible to conclude that Justice del Castillo twisted the advocacies that the works espouse. And that was the case of Justice Castillo. So these are some questions that we are to be guided. So is the material protected by copyright? Is the reproduction, for instance, of the material substantial? So is there a permission in the form of license? So is it a digital licensing or based on Creative Commons, or is the material under an open access? Or is it allowed under the law? So we have to be guided by the fair use doctrine, as we have exhaustively discussed as well this afternoon, whether it is for educational purpose or should it be for personal use. So if it's for educational purpose, you have to take note of the limitations. Again, take note of the limitations that it should not limit or hamper the rights of the original author substantially. So is there a need for copyright clearance? But it's always safe if we can get the clearance from the author or the owner, then we have to get the copyright clearance from the author. So if we have questions on infringement or intellectual piracy that is now presented to the universities, colleges, or even to the professors, we can make use, if you are the author or the owner of the copyright, you can send, as part of your initial remedies, maybe send demand letters or take down notices, especially if they have posted the same in Facebook or in YouTube or other platforms online. So you can ask for takedown notices. So you have to comply with the reporting mechanisms to the institutions, maybe to the universities or colleges who are, or which are utilizing these materials of yours. And at the same time, the universities or colleges are expected also to, to respond to this particular reporting mechanisms, reporting to the appropriate agencies like the IPOFIL and NBI or the PNP, for instance, if it is if there is a clear infringement or if there is a need for entrapment, especially for those persons who are engaging in the sale or reproduction, for instance, of books and films and others. Assistance for investigations and filing of cases. So you proceed with filing of cases. We can also go into alternative dispute resolution. So take note of the negotiation, mediation, arbitration, and the combination of mediation and arbitration. I think the IPOFIL has mechanisms for this. And for the universities and colleges, I think we also have to strengthen this particular aspect of ADR so that questions on academic infringement or piracy or others can be resolved within your institutions already. So what actions can be filed if you are the author or if you are the owner of a copyright or you are exercising an economic right over the matter? So criminal case, you can file that. Administrative suit or civil infringement lawsuit that you can file against the respondents or the persons committing infringement. So you can also seek for injunction, or you can ask for the for the other person to enjoin from committing further the reproduction or infringement. So damages, impounding, destruction, moral and exemplary damages, seizure, imprisonment, and others. So admin, civil, and criminal. And there are criminal penalties, so you can look into the violations under the law. So I think that would be ending my presentation. So as a final note, maybe this, we celebrate our intellectual creation. So in so doing, we put value to another's work. More than ever, even the law allows valid and legal exceptions, that we must not neglect the rights of others. Their copyright must be respected. We continue to learn and innovate. These are my references, and thank you very much.
Thank you very much, Dean Taton. Thank you very much for sharing specific cases and legal remedies on this issue. And it's really helpful that you provided us the alternative actions that we can use for our, in case we know certain legal infringement. I know a lot of our, we have 15 questions here in our Q&A. So I would just be facilitating most of these questions. Now I'll be requesting our speakers to answer the queries. Sorry, I need to open the queries here. Okay, so I think some of these questions are already been answered. One question is to Dr. Shriram. I think it has been in the presentation, but he might have some thoughts on this. The scanned chapter of a book, 10% the scanned chapter of book, can it be available to faculty via email, meaning to say sent 10%, and can this be reshared to the students of that faculty? I mean, have you encountered those kind of issues?
Yeah, actually, this is a very pertinent questions. In fact, it is not advisable to share anything in a public domain until and unless it is going to be used by personal use for the purpose of academic and research. So, as a librarian, we always come across that can we share this to students. So we always advise them not to share in a public domain, rather provide the links so that they can visit to the library platform and they can access those materials too. And in some cases, we do help our faculty member by scanning the content uh, to a limited portion only. So as per rule, it is general rule is 10%. So again, we try to console them that please do not share among a large number of students. So it may be again multiply in a different way. So using in a controlled way is the solution for that.
Thank you, Dr. Shri. Any other thoughts? Dean Rodel, Director Kuyo?
I will leave to Dr. Kuyo to answer that. Director.
The 10% rule. Sorry, Director Kuyo, you're muted.
In the case of the Philippines, we do not have that particular rule established yet. That's why, as part of the process in coming up with more definitive guidelines on fair use, we are inviting all the stakeholders to a dialogue so that we can come to an agreement on what is best given the context and the situation now, and given the balancing the rights of both users and the rights holders.
Okay, thank you so much, Director Kuyo. I know, yeah, there's so much changes that's going on, and the implementing rules would really be very important for everyone. Another question, and I think this is also directed to you still, Attorney Kuyo. So from Fernandizon, he said that is field calls authorized to accept and process requests for use of U.S. copyrighted materials like book chapters and journal articles to be posted and stored in learning management system. U.S. copyrighted materials.
Before I answer the question, I'd like to apologize to Dean Rodel. It seems that there was an overlap in some of the in our presentations. So apologies for that particular situation. To answer the question, yes, what happens is that collective management organizations locally enter into what you call as reciprocal agreements. These are agreements with their counterparts in other countries. So what happens is, if they now enter into a reciprocal agreement with their counterpart in the US, whatever rights are being represented by that counterpart can be enforced by the local collective management organization in the Philippines. So for example, they entered now in the US, and the book or the author happens to be among the members or is represented by that CMO in the other country, then PhilCalls can collect, and then it will remit the royalty to the CMO in the other country. So yes, there is a reciprocal agreement. That goes the same for all, including music. So if you need to ask permission for American songs, then you can always go to PhilSCAP, for example.
Thank you so much, Director Kuyo. There's another question here. I also received an FB question. I think the first one from Maria Elaine de la Cruz, which was answered by Dr. Shri, is very related to what to an FB query here from a librarian. So his question is about scanned portions of books. So at this point in time, we have this in the library, what we call as document delivery service. So what he was asking is like in some instances, the DDS, the document delivery service, would request for only one chapter, but so we scan a chapter of that. But in the long run, the whole chapters has already been scanned. The whole book would already be scanned. So is there a violation for that matter, or should there be a policy that we need to stop at certain point, and any suggestions on how the limitation should be? This is a question I'm throwing to everyone here, to all the speakers.
Uh, 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 we have an agreement with our one of the agency known as Delnet, so Developing Library Network. So this Delnet, what basically do is it send us the suppose any material which is not available in our library, so we can always ask them a copy of that. So in that term, we have a very clear understanding or OMU signed with the agency that if anything, any material which is has been received through document delivery services, we are free to use, and that should be free from the copyright violations. So under that circumstances, we are fortunate to use those things without any problem.
Thank you, Dr. Shri. Anything you wanted to add, Dean Rodell?
Yes. As to this particular practice, I think the libraries here and the organization in the Philippines should have a clear policy on that because of the limitations as provided for under the intellectual property code. And as to the as to the delivery of chapters, for instance, it will sometimes turn out to be the entire book already being delivered from to different persons or to the different libraries. So I think this has to have a clear policy in relation to the intellectual property code of the Philippines because the photocopying of the aspects or the portions of books may have violated also the concept of fair use, and even if it is for the purpose of educational or even if it is for educational purposes, because it might have diminished or have a substantial impact on the right of the author or the creator, director.
Yes, that's correct. But remember that these rules were created or designed at the time of where it's possible to have face-to-face interactions. That's why I'm saying we really need to get back together again and agree on certain guidelines that will balance both the rights of the copyright holders, such as our friends from Philcalls, and at the same time enable our users, such as our students, from having a greater access or freer use of materials given the situation.
Thank you, Director Kuyo. Okay, another question here. So still on document delivery system in the library. In some cases where a copy or usually when we subscribe to ebooks, there are times when there's a password required, but he's asking if there is a violation if like a downloaded book chapter or book that has been sent to the first library user with a password, if he has already downloaded it and he sent or reshared it, say to a classmate or to another faculty, is this a violation of copyright, or is it a copyright infringement? I would give it to anyone who's interested to answer. Yes, Director Kuyo. Ebook. The ebook, passworded ebook.
I think if I may go ahead, director, because I'm looking at some of the aspects of even in the arts or even in this particular aspect, books in the libraries, and the purpose of the password is for the exclusive use of the person who is borrowing or is given the right to access this particular material. So if we have a clear guideline on this that has to be created, I think this is a security feature that would even protect the owner's rights and the library policies also, because it will limit the use of this e-materials or e-books, and the password is a security measure that should be implemented in the light of the new normal and the new or current developments. But I think the the value would still be on the concept of fair use, and sharing this particular ebooks or e-materials to others outside of the permission given is a violation of copyright law.
Thank you, Dean. Anything else, Director Kuyo? You have something to add?
I think I would have to agree with Dean Rodel on that particular aspect. The password is there to ensure that unauthorized access and sharing of these materials uh, is guarded, and therefore anything that will contravene that particular uh, aspect will have to be treated as a violation of the author's rights.
Yeah. Okay. Thank you so much, sir. Yeah, and besides, me as a faculty, in my experience in different countries, once you have a password protected ebook, whatever format it has, I think in my experience, once it has expired or it is password protected, there's no way to reshare it unless you do some hacking to it. So technically, it's already a clear violation to that. Dr. Shree knows about all these things. Yeah, so I think on just a plain and simple term, when once it's password protected, I totally agree. It's something that does not need to be shared. It's directly saying that it should not be shared. Let me check. We have a bunch of Q&A. We have the chat room. So I think we have answered all the three. Okay, so we have questions here. Let me see. Okay. Uh, okay. As part of, okay, we have a bunch of questions from the chat room. One here is that as part of the company's employee engagement practices, it has a radio program streaming music worship songs online, which only the employees can access, those who were given a link. Is the company required to obtain a license for streaming music online for its employees? Yes, whoever wants to answer this question.
Either Dean Rodel or I will answer the question. The answer is yes, there is a requirement for the securing of license for that particular case. Why? Because this is not considered as private performance of that musical work because it's already public. Private performance under the accepted definition of what is private is within the confines of your family, and therefore uh, streaming the musical composition to the entire company would be considered a violation already of the right if no permission is requested from the author thereof. So yes, there is a need to secure license.
Okay, thank you, sir. Dean Rodel, anything you want to add?
Yes, I agree with Director Pio. Especially now, you have to remind in the company, even in the school, sometimes there are aspects that would require licensing. Even for the students, we have to remind the students and even the professors here. Others would download, for instance, something from YouTube, or even if it's a music or whatever, and then they will be using that for a material for their educational purpose. While it is for educational purpose, again, there are questions on fair use, and in the CCP, where we have been faced with many issues on like artist rights and derivative works on the matter. I think it is always good that we get the license. If it's from the online material, we have to seek a license from the from where you got that, or if the author's link is there, you can seek for the license. And the importance of licensing here can cannot be overemphasized. That that for the academe, we have to have a legitimate source of the materials that we are using, and especially for music and the arts and other materials, we have to respect the rights of the authors and creators.
Thank you, Dean. I think Dr. Shri Ram has expounded or has explained about licensing and Creative Commons. Dr. Shri, do you have something to share?
Yes, it is very important because in case of like we have taken licenses in terms of number of users are going to use. So similarly, this is going to be applied for such kind of activity where where in fact publishers or vendors, whoever is providing the material, they generally ask how many persons are going to use. So especially the business cases, and we are taking it from Harvard. So we have to provide the number of students or number of faculty, how much they are going to use. And based on those things, we generally seek the billing and all these things. So I think this is fair to take the number of licenses, how many people are going to use those things.
Yeah, it's really true. Thank you so much. Moving further, there's a question from Devi Galang. Can we copyright online course modules prepared by faculty? I don't know exactly how it would be qualified. We is she referring to an institution or her as a faculty? But that was her question. Can we copyright online course modules prepared by faculty?
So
Yes.
Yes, Dr. Shui first.
yeah,
Okay.
so anything, it can be copyrighted whenever it become a tangible format, like it is coming into the public domain. So automatically it will be copyrighted material, because whoever first compiled and put into the public domain, so it's automatically become a copyrighted material for the particular faculty. So it's now question is who is going to like in our case, we have a very clear in our policy that if faculty member is going to create, so jointly the copyright will be owned by both the institution as well as faculty member. So then only it will be like authoritative source that who is going to take responsibility in case of something happening at later case. So it's always true that whoever is involved in the creation or development of the content, he should own the copyright for the purpose of safety.
Thank you, sir. Dean Rodell, Director Kuya, you have anything to add?
There are there are some questions, especially for the faculty. Like I'm dealing with the faculty also. So here, one of the questions there would be: is is the author is the author or the professor owner of that copyright? Since it is in accordance with or in consonance with his employment as a faculty in his particular employment as faculty in the same university, or will it be the university or the college that will own the copyright for that work? So there are questions that may be raised on the aspect of copyright here. But number one, the professor has the copyright over the his work. But the question on the employment would come in as to whether it is in relation to his his employment as a professor. I think there has to be a clear guideline on this, particularly for the academe, for the universities, that that it has to be a clear it has to be a clear policy, because as a professor myself, I want my materials protected, because this has been utilized for my syllabus, for instance, is being used for all my classes all over the Philippines. And if someone will be owning that, I think it would be prejudicial to my to my economic rights and moral rights on the aspects economic, because it is part of my tool for my teaching and my expertise on the matter, and moral because I was the one who prepared for that, and I have the all the attributes of ownership on that aspect. But I think that that has to be clarified in the policies in the schools, because I have read several materials outside of the Philippines that would state that the syllabus can only be used for one semester, and after that, it doesn't go to the ownership of the college or the university after the semester, or the next school year or whatsoever. So I think a a, a, a policy initiative on this aspect would help our professors and the academy. Director Kuyo, on the aspect of yes.
Uh, Again, I will repeat that Section 230, many of these gray areas in terms of who owns what intellectual property belongs to the faculty, to the student. Most of this can be covered by university policy on intellectual property. So we encourage everyone to actually craft their own intellectual property policy in the school.
Thank you, sir. Another thing, still about materials in the library, mostly the library. Is Esther Pablo is asking about, is the consent of the author of a thesis or dissertation needed before it will be scanned and uploaded for public use? What if there is no author consent? Does the researcher of that particular thesis or dissertation, can he or she keep it? I think this is something related to library. I'll give again first the floor to Dr. Shri.
For the purpose of thesis, we have a very clear copyright policy. So any creator or any thesis writer, if he is submitting any thesis to institute, he should sign an agreement that his work or her work is going to be public immediately once it is going to be submitted to our digital repository. But we have given liberty to the faculty and students, so they can opt for embargo period. Suppose in case if they want to publish some kind of their data at later stage into any journal, or any they wanted to convert the thesis into a book or any other projects, so they can always opt for an embargo period of maximum of 3 years, because we wanted to promote our research activity must be available to other person, so that their institution visibility and visibility of the author must be known to other part of the world. But at the same time, we also give them the liberty to out for embargo period. So this is true that we should take the author consent before making any document to the public.
Thank you, Dr. Shri. It's good that your university has a clear policy on that. Anything else? Dean Tatan?
Yes, ma'am. Thank you, Dr. Reza. As to the aspect of publication of the dissertation, I think this one is really a university policy that should be clear for the students, and also for the researchers who will be utilizing the materials available. I, for one, have noticed in, like, in PUP, for instance, in the Polytechnic University of the Philippines. They noted in their thesis that they have an agreement there that it is a co-ownership or co-authorship aspects, and there are certain stipulations. I just cannot remember now. There's the other stipulations, and and in other universities or colleges that I have taught theses also. There are policies, and others do not have a clear policy on the aspect. And but the students are informed from the very start that their work is displayed in the library, and the same may be accessed by students for education and research. But as to the publication of that and reproduction, I think that has to be reserved and be compliant with um, intellectual property law.
Thank you, Dean. Anything else? Attorney Kuya, you have some words on that?
Yes, I think as I said, that has to be laid out in a university policy on the submission of this thesis or dissertations. And it has to really be very clear, because a license or a permission to display it and to have it available for researches physically in the library may not necessarily constitute a permission to have it digitized and shared, especially with the online mode now, where you have a large number of possible viewers or persons accessing the work. So it has to be laid out very clearly in a policy of the school which ones is allowed and which ones are the limitations of that permission.
Thank you, Director Kuya. I think this next question is has been discussed by uh, Dean Taton on alternative um, actions. Um, how to prevent someone to use our writing and publish it under their own name. This person and I used to agreeing upon writing an article together. But in the process, I am the one who has done 80% of the writing of the article, since his original writing was full of plagiarism and copyright violation. I have changed my mind and decided not to publish the article and tell the person not to publish it. What can I do if the person is obstinate and decides to publish the article with him as the main author without mentioning my name? How can I trace the article if it is published in a conference? Uh, First, I think the legal remedies he was asking for.
Sure. I think for this particular question, there has to be a for co-authorship or partnerships in writing. I think from the very start, like even in just like in ordinary business or in any other intellectual endeavor, I think you have to be clear from the very start as to the the terms and conditions as to how your partnership would be, and that would lead to even until finalization or publication, or even as to the choice of publication. I think all this must be agreed to in black and white from the very start, because we also don't know what happens, because here we can see a clash of rights and interests between two parties, but it would be um, it would be left later on to the law to decide. I think licensing, or here in this case agreement, would be a proper remedy for the parties, or if it has already been done and published, I think the parties should talk to each other and negotiate for whatever means that they can resolve the matter.
Okay. I think as a librarian, Dr. Shri has an idea. The next his question is how is he going to trace uh, to identify whether the publication that the research that they wanted to publish was published solely by the co-author. I know there are tips, there are tricks that we do in information retrieval to be able to identify that. Can you expound on this?
If it is already published and it is in public domain, so naturally by going through the different databases and other things, they can find out. But the problem is how to deal with that. So it's very clear that has been given by Dean Roding. So before it is got published, both person must mutually agree that the content which they are going is actually not going to benefit any of us because of the plagiarism and other things. So the other option is anyhow, if it is published, then the only thing is to report. One option is report to the editor, but actually it is not going to help anything. So editor himself or herself just put the ball into other courts. So I think there is no permanent solution for such kind of activity. Only thing is to understood each other's how to deal with this.
Yeah, that's true. That's true. Director Kuyo, is there a stage where they could already go for legal remedies on this, just preventing the publication of the material, or how could it be when it has already been available online, even just abstracting this material?
Yes, in that particular case, I would really have to agree that in hindsight, they should have clarified really the terms and conditions governing them as co-authors or co-creators of the work. Yeah, it's a very difficult question.
It's a case-to-case basis,
Yes.
right?
Yeah. So
Yeah.
I just add one thing. So there was a very peculiar case from our institute. So one of our senior faculty member, his work was word by word, line by line, was copied by someone else and claimed higher degree. And when we communicated to the repository owner, we just got one clear message that please write to the vice chancellor and write to the author of that person why she has done this work. So just to because we know that if we write to the vice chancellor or if we write to any higher authority, a severe action might be taken against the person who has completed the material. So just in good faith of like on moral ground, we decided not to write anything because it is ultimately going to hamper the job of the person. So it is very difficult to deal such kind of problem.
Yeah, that's true. Yeah, faculty is always faced
Yes.
with issues on academic integrity. We have really a lot of questions here, but I think we might be running out of time. So we might agree to answer three more questions. And since there's a demand from the audience of another one, maybe and as Director Kuyo has mentioned, the IPO is planning to have a consultation. Maybe that's another platform that they can share all these ideas or all these thoughts. And we will be sharing the presentations, which is all the guidelines on how you're going to do it. I'm really confident this is really very comprehensive. So I'll try to find three more questions from different platform. I got one from Henry Luce, the Third Library. There's a question on posting online in websites or in Facebook page. Cynthia's asking, do we need to obtain permission to use materials posted on a website? Dr. Shri, would you mind if I start with you? I think you've mentioned this a while ago.
I didn't understand. Can you repeat the question?
Okay. She's asking if when they're posting photos or information in or any material on a website, do they need to ask permission before posting it?
Posting of URLs and posting of other materials, if it is,
Yes.
it's general. In general, it's not required unless and until specified. Like
Yeah.
for example, there is a National Academy Press, so there are huge materials available online, free to use. But they again say that before posting any material, we have to, even they are free to use, but at least this they should seek some kind of permission that they are going to use for this material for their website. So in certain cases it is not required, but you have to see that if any kind of material you are posting, so you must assure that what kind of rights you are going to have through that website. If it is clearly mentioned that you are free to post, so you are most welcome. But if it is certain kind of guidelines, so I think you should go abide by those guidelines as well.
Yeah, thank you so much, Dr. Sri. I know you've mentioned about public domains, how to
Yeah.
access those public domains, and the licensing, the Creative Commons is really a good first-hand starting point for all these things. Anything else from our two speakers? Dean Rodell, do you have something to add?
Um, in relation to this particular matter, um, I think that actually I didn't get much of the question, but in relation to what was said earlier, um, uh, I have to say that I'm sorry, I got lost in in a bit because of the matter here. But again, as to the use of online materials or the materials online that we get to use for the classes here or in the academe, we always have to be reminded that if there is an opportunity for us to verify as to the ownership or the policy guidelines, or if this particular website as an online guideline for intellectual property rights, then we have to check on the guidelines or for you to be compliant. And if there is no clear policy guideline in there on intellectual property rights, then it's always good to communicate to or contact that particular website. Or if if the portion can only be is not so substantial and can be justified by fair use, I think that that can be allowed, and it's just that we have to attribute to the author and the source of the material that we are using. So I think there are questions I earlier posted there. If there are 5 questions there, that whether we have to secure a license or not, but for safety purposes, it's always good to be compliant and secure the license of or permission from the creator or author.
Thank you, Dean Rodell. That's pretty comprehensive. Yeah, it's true. Attribution is the key. Director Kuyo, something else?
I think I will answer that more generally. I think the question is coming from the common misconception that when a material or a work is posted online or such as in a website, that it's free of copyright. That's not correct because even Creative Commons have copyright, except that the use thereof are more liberal than getting permission, for example, under a regularly copyrighted work. So it's a misconception. As mentioned by Dean Rodell, you need to look at the ownership if there is such copyright in the work. And these are also available in the websites where they are posted.
Okay, thank you, sir. Another thing here. Okay, the last two questions that I'm trying to uh, get. So this is again about library collection, but I think it's related more in the copyright in the Philippines. What if we digitize our library collection of locally published books and rare books, upload it on an online repository, make it available for online viewing only by the members of the university for the purpose of access to these books remotely in supporting teaching and learning. Will we violate the copyright? I think I'll give this first to Director Kuyo on
Uh,
Filipiniana books.
Filipiniani books, the law on exception under the copyright law, in particular, I'm referring to Section 188 of the law on reprographic reproduction by libraries. I think given the new context, there is really a need for us to discuss this better, because ito kasi is it talks about reprographic means, and it does not contemplate the digitalization uh, of the collection of these libraries. And it's very clear under Section 188, the purposes should be preservation, or where there is no more copy, and it's limited, and the making of uh, the reproduction is only for a limited copies in order to preserve the work. So I think there is a need to further discuss this provision of law if we can come to an agreement between the rights holders and the and the users, such as the libraries. Because from the end of the copyright holders, I think they need to be sure how many really would be accessing the work. Because other than for preservation, if it's Filipiniana collection, I think you might uh, you might find a justification for that, or it's a rare collection, you might find a justification for that. But for regular copies, regularly published works, uh, there might be a problem.
Okay, thank you, Attorney Kuyo. Dean Rodell, you have something?
Not to agree with Director Kuyo on this aspect, because the policy is not yet into the digitization aspects that has arrived late in the day lately only, and as to delicate matters involving materials in the Filipiniana section, for instance, or others, I think there has to be a clear rule on that, because the accessibility, I think it's not even a question of accessibility, but it's a question of respect and protection of the ownership and the copyright of the person or the authors or creators.
Okay, thank you, Dean. Dr. Oh yeah, this is Filipiniana materials, but do you have any thoughts on sharing and digitization, putting it in a repository for only for the university consumption, for faculty and students consumption? Is there anything else that would be violated if that's the case?
For me,
uh, if you have some thoughts about in general
okay.
putting in digital repositories some local materials.
Okay, so in Indian copyright, in section 1 of exceptions, it gives that we can store the maximum of 3 copies. I can't say it is digital. Maybe we can convert into a digital format as well. But if it is not available within our territory, so certain kind of exceptions are available where we can use. But we should be very careful about the respecting the author's right.
Yeah, that's true. There's no hard and fast rule in that. Another question here. If this is directed to Dr. Shri. It's about Indian copyright law. Is controlled digital lending allowed as per Indian copyright law? Controlled digital lending.
We have to follow the standard agreement which had been agreed with the publishers. So controlled lending is means we are free to provide through remote access or password based access to the our users which are registered. So I think that is one of the option we can.
Thank you so much, sir. One last question. We really have a bunch of questions here. What I can do probably is summarize this, and most likely your presentations have answered this. And so I'll just read the last question here before we wrap up. The question here is it okay to download a video from YouTube, for example, using a video converter, and use it as a reference or material for instruction? So this is about instruction. Can I give it to you, Dean Riddell?
Yes, we have we have been faced with a particular question in our last webinar with Director Kuyo in the arts and digital piracy. And one of the questions there is if it is allowed to be undownloaded, or is the community standard of YouTube allowing that. So you review the standards there by YouTube, and as to even if it is allowed, can we be utilizing that for our purposes in instruction and in teaching online? I think again we have to be guided by the questions there, and there must be an author or creator of the video that you have to seek permission from. And so I think it's better to write a message to the person or the author of the video as posted in YouTube, because for sure it is protected for by copyright laws, even if it is outside of the Philippines, or I mean the person who downloaded that would be coming from outside of the Philippines. Again, here we must comply with our with our copyright laws. And if if uh, and again we have to be guided by fair use, always fair use, and for the purpose of education, and whether or not we will be simply copying. So for teachers, professors, we can always download materials online, even if we have access to or permission from the owners or the authors. I think utilizing that for our own purposes should not only be facilitating, but also should be encouraging us to make more materials that would be utilizing this available material, but also including our own creativity, innovation, and and intelligence for us to make use of these materials.
Yeah. Thank you so much, Dean. Director Kuyo, any other thoughts on this?
Yeah, I'm trying to look at the provisions of the law on fair uses and whether you can find an excuse there or justification there for downloading a YouTube material. I think we will have to look into the possibility of 184(1) which is the inclusion of a work in a sound recording, or if such inclusion is for purposes of teaching for illustration purposes. But I think as a general rule, if you copy the entire thing and use it uh, for your teaching, it may be hard to justify, because even the inclusion of a work for teaching purposes must only be to such an extent necessary for that purpose, and certainly 100% of a work may not be uh, a justifiable extent for teaching purposes.
Thank you, Director.
Excerpts siguro. If we're talking of excerpts, I might.
Mhm.
There might be a justification, but the entire thing certainly would be harder to justify as a fair use for teaching purposes.
Thank you, Director Kuyo. Dr. Shri, any last thoughts on that?
I
Use of
agree with both the person that it's very difficult to justify that if you are using whole content as better is to share the link, or better to uh, use certain part of the work which is comes under fair use policies.
Okay, thank you. Thank you. So, well, it has been an immensely fruitful discussion, and I am much indebted to our resource persons who share their time and expertise this afternoon. I know you have a lot of questions, but we might still have other platforms to answer that, and we'll try our best to help facilitate answering all these issues. As emerging technology continue to be part of the new normal, I'm fully aware that we need to keep abreast and we must be conscious and conscientious about intellectual property. May I leave the last parting words to our resource speakers? Probably I'll start first again with our first speaker, Dr. Shri. Any last parting words
Yeah,
for
thank you.
our participants?
Thank you so much for giving me opportunity to interact with a person like you, as well as our Professor Kyo and Professor Dean Rodden. So I think it was nice to meet you, these two gentlemen, through this virtual meeting. Thank you so much.
Thank you, Dr. Shri. It's really a pleasure to have you as our speaker. Next, may I give the floor to Director Kuyo?
I think my message would be that to encourage as much as possible the creation of original literary or artistic works. But if that's not possible, because I understand and I realize that you have to have the skills and you spend time also in the creation of a work. But that's the best option for you. If not, then there are available remedies or there are available remedies under the law whereby you can actually use or incorporate the work of another into your work without violating copyright. I guess the point really is copyright should not be an impediment to online learning or to the education of a greater number of the public. Uh, we just really need to have a better understanding and grasp of the law. That's why the Bureau of Copyright is here, and we participate in forums such as this to bring about a greater education and understanding of what is and what is not allowed under the copyright law. Thank you.
Thank you, Director Kuyo. Dean Rodell?
Thank you, Risa, and thank you to our two guests here who share their knowledge in our forum that we have prepared for the librarians here and the academics. And I thank all those who supported this activity. We apologize for the earlier problem of connections, but I think it's also part of the new normal. And as a parting word, maybe I would I would always remind the academics, even the all of us, that if we are dealing with another's work, it is already a warning that we have to check whether it is protected by the law or if it is falling under the exceptions. And if it is under the exceptions, can we fully utilize that and treat it as our own creation? I think it's the answer there is no. But it reminds us to celebrate our own creativity and intelligence, and for us to be able to fully engage in this new normal in the academe. I think we have to develop our course outlines, syllabus, and even in our preparations as a professor and as we deal with the students, we have to teach to them that another's work is protected and we have to respect that, and that our work is protected and others must protect that as a as a copyright as well. And maybe this talk is a reminder that the new normal is not an excuse for us to copy one's work or creation, but we have to make use of this new normal as a way of fully celebrating new types of creation in the digital world and even without going face to face, we can create. Thank you.
Thank you so much, Dean. I'll try to turn off my FB Live now. I think since we're already closing, hopefully
May I
I'll get
use
in.
online?
Yes, Dr. Shri.
Yeah, so as a point, librarian point of view, I just wanted to convey a message to everyone that there are huge resources available everywhere. Only thing is we have to liaison with your librarian so that they can help you in understanding both the concept of the copyright as well as providing the resources which you actually require for your teaching and learning. So that, I think that is the best solution. We can handle the pressure of violating any copyright activities in teaching and learning.
Thank you so much, Dr. Shri, and thank you so much to you all. Unfortunately, this tech glitch is not going well with me. I can't see you all, but anyway, you can see me, but I'm there with you all. So yes, thank you so much. Your thoughts, your sharing, your expertise just proves that we do not stop intellectual fruits to flourish. We are in this together still up to this point and within the new normal. And so thank you all. I really thank everyone for participation. It's been a pleasure to have you all, and have a great afternoon. Probably I'll do some parting shots for all of us with me not in the video, okay, just for posterity purposes. So let me do this screen sharing. Okay. Okay. Thank you so much, everyone, and goodbye. Have a great afternoon to all.
Thank you.
Thank
Bye.
you.
Thank you, Director.
Thank you, Dean, and thank you, Dr. Shri. It's a pleasure meeting you.
Thank you, sir. It's a pleasure.
I
Thank
think
you.
we really have to collaborate on the uh, next activities on this, sir. This has been very good.
Yeah, and it's getting global.
Yeah.
It's my pleasure.
Yeah.
And hopefully,
Thank you.
time we have met with the Association of Libraries, because they
Mhm.
are really a key mover in terms of the issues surrounding digital reproduction, sharing online, etc.
Right.
Yeah, yes. Yes.
Thank you, Dr.
Okay.
Raisa.
Okay, bye. Thank you.
Thank you.
Thank you.
We will share the video online kasi we have
Yeah. Yeah,
earlier.
I'm just copying right now the questions that we haven't answered so that our team will try our best to answer them.
Yes, and we can send
Okay.
you.
Yes.
So I'll be here for a moment.
Sige, sir. Thank you,
Okay,
Thank you.
thank you.
Thank
Thank you.
you.
Bye-bye.
Dr. Director Kuyo. Thank you po.
Thank you po.
Next
Hindi
time
naman
ulit.
ganun. Hindi, na din pa ko, kay kakopya pa ko di. Kabudlay kopyahon.
Wala
Dali
tao.
lang. Ang sound mo Japon, dali lang. Nadula ako niya video man.
Wait lang, may mga attend.